Diplomacy, the military, international affairs, national security, these are things that can raise complicated, sensitive issues of constitutional law. There are many things that one can say about it, different ways of looking at it. One major question is whether the constitutional rules should be any different for this sort of thing. In other words, when you're trying to decide what constitutional law should be, does it make any difference if you're dealing with a purely domestic issue versus something with international or foreign connotations? The Supreme Court's decision in Missouri v. Holland was an important case in this realm. It was about a treaty. A treaty simply means an agreement between two or more countries. The crucial bit of constitutional text for this issue is in Article 2, Section 2, where it says that the President shall have power, by and with the advice and consent of the Senate, to make treaties, provided 2/3 of the senators present concur. So the President is supposed to make the treaties, and then the Senate decides whether to ratify them. Now, there are a couple of special things about this. One is that it involves the Senate and not the House of Representatives. Normal legislation must be passed in what they call a bicameral way, meaning that it's approved by both houses of Congress. But here, with treaties, it's only the Senate that is involved. And in addition, it requires a 2/3 supermajority rather than just a simple or normal majority of the Senate. Why would the framers of the Constitution want to have treaties ratified by the Senate alone and not the House of Representatives? And why would they want to require a 2/3 supermajority of the Senate to do so? They basically thought that the Senate would be better equipped to handle this responsibility. For one thing, the senators would be serving 6-year terms, not just 2 years as in the House of Representatives. And the Senate would be, to some extent, an upper or more prestigious chamber of the legislature. So the framers of the Constitution felt that senators would be more experienced. They would be more knowledgeable about world affairs. And with their 6-year terms, they would be able to confront foreign policy problems from more of a long-range perspective. So you might have more wisdom and experience and stability if you gave this task to the Senate. In addition, the Senate was going to be smaller. It would have fewer members, and its small size would be more conducive to the secrecy and the speed that you would want for foreign negotiations. It's easier to keep something a secret if you don't have to tell as many people. In addition, by putting this responsibility in the Senate's hands, it would be something in which every state would have an equal say. Every state would have the same number of senators, 2 senators, and so the big states wouldn't have any more weight than the little ones. And that was the way it had been prior to the Constitution's adoption under the Articles of Confederation. Under that system, it took 9 out of the 13 states to ratify a treaty. In other words, it required 2/3 of the states. And that was seen as an important protection of the states, particularly the southern states. If the northern states all got together and tried to make some sort of commercial agreement or other treaty that would favor northern business interests, the southern states would be able to block it. And so that same approach was essentially recreated in the Constitution by saying that the Senate had to ratify treaties by a 2/3 vote. In Missouri v. Holland, the dilemma was that the federal government was trying to do something using a treaty that it could not do through normal legislation. Congress had passed a statute to regulate hunting of migratory water birds like geese and ducks. Congress figured it had the power to do this because the birds are migratory. They travel across state lines. So it seemed like something for the national government to regulate. But the statute was challenged, and a couple of courts struck it down. They said that the Constitution didn't say anything about the federal government having any power relating to birds, and the law therefore infringed on the state's authority in violation of the 10th Amendment. Remember that this was back in the early part of the 1900s, when the courts construed the federal government's power more narrowly, back before the New Deal. So the federal government was disappointed about this statute being struck down. And the President, Woodrow Wilson, told the Secretary of State to go over to England and negotiate a treaty with them about this. And they came up with a treaty requiring the United States and Great Britain on behalf of Canada to enact legislation regulating the hunting and sale of these migratory birds. So Congress then enacted legislation pursuant to the treaty that did essentially the same thing as the previous law that had been struck down. So they tried to do this under a statute. They ran into constitutional difficulties. So they got a treaty and then enacted a statute pursuant to the treaty. The state of Missouri filed a lawsuit and said, hey, you can't do that. If Congress doesn't have the power to enact certain legislation, you can't get around that simply by signing a treaty with some other country that provides for the enactment of the legislation. But the Supreme Court disagreed. They said this was okay. Justice Oliver Wendell Holmes said that the federal government has the power to make treaties, and that includes the power to enact legislation that carries out the treaty obligations. Some people think that was the right decision, but some think it dangerously expanded the powers of the federal government. Is it creating too big of a loophole for the federal government to be able to do whatever it wants? Or is it wise not to interfere with the conduct of foreign relations? A lot of people strongly criticize the Missouri v. Holland decision, and they think it's dangerous to say that a treaty can expand the federal government's power to legislate. The case has never been overruled, but would it be followed today? No one knows for sure. For example, imagine when Barack Obama was the president. Imagine that the health care reform law that he was trying to enact that got struck down as unconstitutional. Could President Obama have gotten around that by entering into a treaty with some other country like Canada and then having Congress enact the same legislation pursuant to that treaty? Nobody really knows. Or suppose President Trump wanted the government to do something about an issue he was particularly concerned about, like with immigration or border security, but he found that it was beyond the power of the national government to do it. Suppose he got another country to agree to a treaty that would require this to be done. Is it acceptable for presidents to be able to use their treaty power in this way to get things done, or is it problematic? Notice a couple of things about Justice Holmes' opinion in the Missouri v. Holland case. One is that it's got a very practical, pragmatic, realistic approach. Oliver Wendell Holmes' motto was that the life of the law has not been logic, but experience. And you see that attitude here. He's basically saying, let's be realistic. If we leave this to the states, all of these birds are going to be wiped out. If the federal government doesn't deal with this, nobody will. He says, near the end of his opinion, we see nothing in the Constitution that compels the government to sit by while a food supply is cut off and the protectors of our forests and our crops are destroyed. It is not sufficient to rely on the states. So it's a very pragmatic approach. He's basically saying, look, we got to save the birds. This opinion is also remembered for its eloquent articulation of the method of constitutional interpretation, sometimes called the living Constitution approach. Holmes said, when we are dealing with words that are also a constituent act, like the Constitution, we must realize that they have called into life a being, the development of which could not have been foreseen completely by the most gifted of its begetters. It was enough for them to realize or to hope that they had created an organism. It had taken a century and has cost their successors much sweat and blood to prove that they created a nation. That the case before us must be considered in light of our whole experience and not merely in that of what was said 100 years ago. He went on to say, we must consider what this country has become in deciding what the Constitution means. In other words, Holmes felt that the Constitution is an evolving thing and we have to treat it that way instead of obsessing over what people may have thought when it was originally written. Missouri v. Holland is thus a key ruling on the reach of the treaty power under the Constitution, but more broadly, it's also a provocative comment on the methodology of constitutional interpretation.